Good morning. My name is Eric Cardall, and I'm proud to announce that the Minnesota Sioux Indians of Minnesota have filed a lawsuit in the U.S. District Court for the District of Columbia. They're filing a lawsuit in Washington, D.C. against the Secretary of Interior, the Department of Interior, and the United States. My clients are the Minnesota Sioux Indians of Minnesota, Margo Bellanger, Tina Jefferson, and Michael Childs. I'm very proud to represent them as Minnesota Sioux Indians, and their supporters are here today. And the press conference is going to be organized. I'm going to give a few remarks, and then there'll be a sequence of speakers, and then there'll be questions and answers. The lawsuit has three purposes. First, we are suing the Secretary of the Interior to affirm that the tribe called Minnesota Mdewakanton Sioux Indians is acknowledged by the Secretary of Interior as a tribe. So the Mdewakanton Sioux Indians of Minnesota have been acknowledged as a tribe since 1863, right immediately after the Sioux Uprising. They've been acknowledged after the 1888 to 1890 Appropriation Acts. They've been acknowledged under the Indian Reorganization Act, and acknowledged as recently by the Secretary of Interior as a tribe in 2012. So we've been acknowledged to be a tribe, and then there are these three communities that have been organized under the Indian Reorganization Act. This lawsuit does not in any way threaten, change, or modify the way that these communities operate. That would be Shakopee, Prairie Island, Lower Sioux. Instead, we are seeking affirmation of the acknowledgement of the Department of Interior that there's a fourth group of American Indians referred to as the Mdewakanton Sioux Indians of Minnesota. The first goal, then, is to get the Department of the United States to acknowledge that the Mdewakanton Sioux Indians of Minnesota are an acknowledged tribe under the Indian Reorganization Act. There's a difference between an acknowledged tribe and a recognized tribe. We want to be acknowledged, and then we're eligible to be recognized if we decide to submit a constitution. Goal number two, which is very important, and very, very important, and that is that there are 12 square miles of land in Minnesota that were set aside by the Department of Interior for the Mdewakanton Sioux Indians of Minnesota. In the 1863 Act, which forfeited the treaties with the Minnesota Sioux Indians of Minnesota, it did not terminate the tribes. The Mdewakanton Sioux Indians of Minnesota survived the 62 uprising and continued in Minnesota intact. In 1863, those two acts did not terminate the tribe, it only terminated the treaty. So the tribe continues. And this has been acknowledged by the Department of Interior over the last 150 years. But under the 1863 Act, the February 1863 Act, there was a provision that lands could be provided by the Secretary of Interior to these Indians. And in Redwood County and Sibley County and Redville County, the Secretary of Interior set apart 12 square miles of land, a reservation for the Mdewakanton Sioux Indians of Minnesota. The statute says once those lands are set apart, they're for those Indians forever. F-O-R-E-V-E-R. That statute has never been repealed. Unfortunately, due to local white hostility, even though the Secretary of Interior signed the paperwork to set apart the reservation for this tribe, they decided it was too hard because of the local white hostility, the racism, to put those American Indians there, these people's ancestors. But the statute says those lands are for those people forever. So despite the fact the Department of Interior has publicly sold those lands, it did not have statutory authority to do so. Our client's second purpose in the lawsuit is to establish for the Mdewakanton Sioux Indians of Minnesota a 12 square mile reservation that's already been awarded by Congress and the Department of the Interior in 1865. So you see, once you have the identity, you get the reservation. Third, the federal land assignment system, which was operated for the tribe from 1890 to 1980, was stopped at Prairie Island. In 1996, the Prairie Island Indian Corporation, a beneficiary of the 1980 Act, was dissolved. These folks who are members of Prairie Island would like to see the federal land assignment renewed so that their ethnicity as Minnesota Mdewakanton Sioux Indians is identified through the federal land assignment system. Part of the story will be how their land, which has been held at Prairie Island in their family for over 100 years, has now been taken from them. So I'd like to introduce now an elder at Prairie Island, Darlene Roach.
Good morning, my name is Darlene Campbell Roach. Those of us standing before you are enrolled members of the Prairie Island Indian Community in the state of Minnesota. We are also lineal descendants of the Minnesota Mdewakanton Sioux Indians. My grandparents were Joseph Campbell and Lena Whipple Campbell, who were given land known as the Minnesota Mdewakanton Sioux Assignment, or 1886 land. My family has continually occupied the original 1886 assignment for the past 130 years, until the death of my uncle Joseph Whipple Campbell. From the late 1960s through the 1980s, the United States used to, the Secretary of the Interior and the Bureau of Indian Affairs would call meetings at Minnesota for the Minnesota Mdewakanton Sioux Indians to get our input on various land issues, including opposed sales of the 1886 land, and inevitably did the exact opposite of what, of what we wanted done in these cases. This ultimately leads up to the asking as to whether we were opposed or we agreed the so-called Carter Act of 1980, which would place our individual land assignments in the control of the community. Again, the majority of the assignment holders and their heirs adamantly opposed the Carter Act, and in the past, Congress ignored our wishes and passed the act anyway. From that point forward, Congress and the Secretary of the Interior and the Bureau of Indian Affairs have never bothered or even tried to continue to consult with us as people. I feel this shows a disrespect not only to my family, but to the Minnesota Mdewakanton Sioux as a whole. Now our own community council is trying to erase all mention of my family and my people from our Constitution, which in light of the past actions of certain factions in the community has me fearful of yet a new attack on our rights as community members. My grandmother told me that to watch out for 7 generations, and it is my belief that if we do not act now, there will not be 7 generations to follow me. And that's all I have to say, and I'm going to introduce my nieces, Margo and Tina Jefferson. Margo Bellanger and Tina Jefferson.
Hi, my name is Tina Jefferson. I am married to another member of the Mdewakanton Sioux Indians. My maiden name is Tina Campbell. Both my parents are Native. My father is Joseph B. Campbell, who is a descendant of Antone Joseph Campbell, who is a descendant of John Otherday. They were instrumental in the formation of governing documents of this country and Minnesota. Antone was an interpreter at Fort Snelling, and John Otherday saved white settlers during the 1862 uprising. My family has been involved in our government and the community government for generations. They have been making treaties and writing documents and parties to treaties and delegations in Washington for hundreds of years. I was born in Red Wing. My great-grandmother is a descendant of Chief Red Wing. They came from long lines of hereditary chiefs and avid farmers. The lands at Prairie Island have always been sacred to my family. We have always been able to hunt and fish in the area and gather medicines and nuts and fruits and berries and etc., as we were taught by our ancestors. Life on the reservation had been simple, and the people were close and cared for one another, sharing food and supplies. There were not many families or people who decided to stay on the reservation. I cherish my memories of life on Prairie Island as a child and in my adult years. I enjoyed our freedoms to be able to work or to walk around anywhere, fishing, hunting, gathering, trapping, There was a real sense of this is our land and we get to be in charge of what we do. Oops. There was very little employment or an economy on Prairie Island. Many family members, including myself, had to seek employment at the nuclear power plant, or many left the reservation. My father and my family members farmed the land to sustain ourselves, also to use our lands as stated in our documents. Many of my family members purchased land around the reservation and farmed those lands also. I have been proud of my heritage and look forward to that life to continue as I become a parent and grandparent. I lived with my father on his land assignment for several years. In 1998, I was able to get a land assignment. At this time, this was not an easy thing to get. The community held the lottery because the list was way longer than the land available. I was number 7 on the list. That to me was a very lucky number because of our rich history being one of the 7 council fires that formed our nation. Prior to 1998, there were questions about community members, by community members, as to who we were, and they proceeded to try and disenroll our great-grandmother Lena. They found out that they were related to us. That stopped. Life went back to normal. After the casino became profitable, we were able to purchase more lands for community members, and many came home. My great-grandparents possessed land that my family has occupied for over 130 years. The land title is in their name still to this day. After my great-uncle's passing, no one from the community or federal government contacted us about the status of our land. Due to the acts in 1980 and 1994, the erosion of our rights began. In 1996, the corporate charter was revoked by an act of Congress. This changes the dynamics of the land and raises questions which lead us to where we are at the present. All of the years of my youth, I was told by my grandparents, grandfather, grandmother, aunts, and uncles that you are to go to school, get educated, and learn how to read and understand all these documents. My family members are outnumbered by the community members and have not been able to get seats on the community council for a large number of years. Therefore, we are no longer informed of the many changes the federal government has made involving the elimination of our identity as Minnesota Mdewakanton Sioux Indians' lineal descendants. After many hours of research and discovery, we have put together the puzzle pieces and now see the bigger picture of elimination that is being played in regards to our existence. This concerns us as we know that we have rights that are not being recognized. And so I stand here before you today so that my voice and my ancestors' voices can be heard. We have held our tongues for centuries. Now it is time to say what our ancestors said to us. It would only be respectable for someone to help straighten out the mess overlooked all these years by so many agencies. Thank you.
Hello, my name is Margo Bellanger. As you have heard from all my relatives, we are all concerned with the changes within the Department of Interior and the Bureau of Indian Affairs, not recognizing our legal rights and entitlements. We want our voices to be in the processes and changes within these departments, and to see that our ancestral lands stay within our family. And for our Constitution to be a document that continues to recognize us. This land issue and the rights of the Minnesota Mdewakanton Sioux need to be handled now, so that all of our future generations can enjoy being who they are. Our children are going to be coming up next, and that's Allison Childs, Marky Bellanger, Michael Childs, and Campbell Jefferson.
Hi, my name is Allison Childs. These are my cousins. We are Mdewakanton, Dakota, and enrolled members of the Prairie Island Indian Community. We are here because we believe our family, all Mdewakanton people and all Native Americans deserve what we are owed and were promised. We don't want to see our people lose everything and dissipate in the future. We are not Native American because the government says so, because of the color of our skin, or because we have an ID saying that we belong somewhere. We are Native American because of our ancestors, our history, and because it runs in our blood. We are Native because we are. I know that I'm young, but when I have children, I want them to know that they belong somewhere. I don't want them to have to fight for something that should have been fixed a long, long time ago. Maybe now we can fix this for the future 7 generations. Thank you. And I'd like to introduce my dad, Michael Childs, as our next speaker.
Good morning, my name is Michael Childs, Jr. What started everything with this lawsuit goes back to February of 2016 of this year. In this inconspicuous envelope, our community council, Prairie Island Indian Community Council, sent out proposed constitutional changes. One of the major changes was removing the Mdewakanton Sioux Indians of Minnesota, which references the federal land assignment system on Prairie Island. We had grassroots meetings with many community members. We were essentially blocked from, after a few months of trying to hold meetings in community buildings. And when we met with other members, we had 5 or 6 copies. Here's our original 1936 Prairie Island Indian Community Constitution. We have many other constitutions that the Prairie Island Indian Community Council were using and said were official documents, but they had typos on them. And so we were confused ourselves. So we made comments. We sent comments directly to the Prairie Island Indian Community Council as individual members. We also, as a group, went up to the BIA office over in Bloomington and dropped our copies of our comments off about these proposed constitutional changes. The BIA does not talk to Native Americans directly anymore. They only talk to Native American councils and governments. So when they change our rights as individuals, we are not notified. We brought these numerous discrepancies up, and the council acted like they were surprised, which I think when you're rewriting a constitution, I would think you would proofread all copies of a constitution that are sitting around. And with this, they have made our constitutional revision. The BIA and the Indian Community Council have not been transparent in these changes. They won't talk to us as individuals. At least, they'll talk to you as an individual, but they won't officially respond. The BIA won't. What was concerning about the proposed changes is they were increasing the Prairie Island Indian Community Council's power. Basically, we are getting rid of what we call a federal election system, which would allow BIA oversight of our constitutional changes. They hire and fire community judges. So when you have your judges in your pocket, how are they going to side? Probably with a community council. The other concerning change of the Constitution was the removal of the mention of the Minnesota Sioux Indians of Minnesota, who are founding members of Prairie Island Indian Community and who have had rights of federal land assignments. So early this year also, one of our, the Prairie Island Indian Community Council evicted one of our elders' non-tribal member spouse, which under federal law would be protected. And the spouse was the spouse of our uncle, Joseph Sonny Campbell. And they were trying to take control of the 30 acres that were assigned to my great-grandmother, Lena Campbell. And we have continuously occupied this land for over 100 years. So we are essentially confused why the Prairie Island Indian Community Council and the BIA could take our rights under these Indian land certificates. And that's why we contacted Eric to find out these answers. And finish up, we'll have Eric Cardall talk. Thanks.
So again, thank you, everyone. The three purposes of the lawsuit are: one, for the court to require the United States Department of Interior to confirm its acknowledgement of the Mdewakanton Sioux Indians of Minnesota as a tribe. So it's been acknowledged as a tribe under the Indian Reorganization Act. It doesn't have a constitution. It isn't organized under the Indian Reorganization Act. That's what would be required to be recognized. We don't dispute that the three communities, Lower Sioux, Prairie Island, and Shakopee, are recognized, and under the current Indian Reorganization Act as amended in 1994, that they have the sovereign powers of a tribe. But to interpret those 1994 amendments in such a way to eviscerate and terminate this acknowledged Mdewakanton Sioux Indians of Minnesota tribe is absurd, legally absurd. And the Secretary of Interior knows it. So the little game the Secretary of Interior has played over the last 30-some years is telling these people that they're not acknowledged as a tribe. Now this tribe, we've done research. We've got birth certificates. We've identified more than 7,000. These are the representatives of the 7,000. And so the Secretary of Interior knows these people because they petitioned with letters, with phone calls, with lawsuits for decades. And what would the Secretary of Interior say? You're not recognized. But now we know the game because we're acknowledged. There's a difference between acknowledge and recognize. So isn't that deceptive when you petition the government to acknowledge you and they say you're not recognized? Well, who was here to educate these people that the response should have been, but we're acknowledged? That's the Secretary of Interior's duty to inform the people. That's not their duty to hire a lawyer to do the research and inform them. Since 1863, the Secretary of Interior has acknowledged the Mdewakanton Sioux Indians of Minnesota. The 1863 Act, which confiscated the reservations, did not terminate the tribe. Well, look, Upper Sioux, it was the Sistenwapitan. Well, look, the Sistenwapitan are in South Dakota. Look, in Minnesota, we have the Mdewakanton. The four bands were never terminated, but their treaty rights were taken away. Their annuity rights were taken away. So it was part of the design that the Mdewakanton tribe would reside in Minnesota, as it has, as evidenced by these people who have spoken and the people present. Well, that's interesting, Mr. Cardall. So there's an entity now that's been acknowledged as a tribe that has the ability to sue. And who would you sue? Well, the United States. That's who we're suing. Well, and then we have two land issues that need to be addressed. One land issue is, well, wait a minute. The Secretary of Interior in 1865 set apart 12 square miles for these people. Well, that 12 square miles was set apart under a statute that said if it was set apart, it would be for these Indians forever. And forever is a very long time. And the Department of Interior, without notifying these people, then did its hanky-panky back in the office and said, well, because of local racial hostility, the settlers, white settlers don't want these Indians there. And because it's kind of hard to find them and impractical, we're going to, behind the scenes, restore the 12 square miles for sale to the public. And we have the paperwork. We have the letters where the Secretary of Interior set apart the lands. We have the letters that say, confirming that they were set apart, meaning they were for these Indians forever. Reverend Hindman was designated to move the American Indians of Mdewakanton to that place. And then we have the letter saying that's hard to do because of local white hostility. Then we have the letter that covers it up. The Department of Interior actually recounted all these things and then said, well, it's impractical. We're going to just put it up for public sale. They needed a congressional statute terminating that these lands were set apart forever. There's no congressional statute, so the statute's not repealed, meaning the Secretary of Interior has to follow the law. So in the earlier case, I remember this is very funny, in the Federal Circuit, one of the judges said, well, when are you going to, the Department of Justice, they were asking questions. The lawyer for the United States Department of Justice representing the United States said, well, that Section 9 of the 1863 Act, that 12 square miles, that's never been successfully implemented. And then the judge said, well, when is it going to be successfully implemented? And so that 12 square miles just sits there. And that's, of course, ours. And it's, of course, theirs. And you can do whatever you want with it. The United States and the other people have no say in what you do with your property. But you have to be delivered the property because you're acknowledged to be a federal tribe. With respect to the land assignment system, it's the same. There's a federal land assignment system here. Since the Prairie Island Indian Community Corporation was dissolved, then the issue arises again. And you should get the land assignment, the 30 acres, assigned in your family because it's been continuously in your family, and that should be the preference. But the federal government needs to ensure that the preference continues. So the Secretary of Interior is in deep, deep, deep water. The lies have accumulated. It's lie after misrepresentation after misrepresentation. It's all there. We don't threaten the communities one iota, but we're a huge threat to the Secretary of Interior and the Department of Interior because it's game over. We understand the difference between acknowledgement and recognition. We understand that forever means forever, and we understand the federal land assignment Prairie Island Indian Community needs to be restored. So these descendants are given their proper respect. The last note. The last note is, I think that, as you heard from my clients, the thing that is most egregious from their Mdewakanton perspective is the lack of consultation, the lack of respect, the lack of dignity. And this could be from the community councils, from the lawyers who represent the communities, from all the Department of Interior officials and the lawyers. There isn't the respect paid the Mdewakanton Sioux Indian lineal descendants. They deserve respect. They deserve to be respected based on their legal identity, on their personal identity, their cultural identity, and that's it. And if the people at the communities, the people at the lawyers for the communities, the government officials and the government lawyers want to take a step forward, they would show that respect, and they'd have consultation. But without consultation, there will never be peace. We'll just have lawsuits. But this lawsuit isn't going to take that long because it's so simple. The Secretary of Interior is obviously a legal error. We'll take questions. Thanks for coming.
Thank you. Thank you.
Are there any questions for any of the participants?
Can you explain the 1996 act or whatever?
Right, Prairie Island Indian Community in 1996, the corporation, the people of the Prairie Island Indian Community voted to revoke the corporate charter, and that had to be done by statute. So in 1996, Congress passed a statute revoking the corporate charter. And under the 1980 Act, the Carter Act that Arlene talked about, the interests under the 1980 Act were held for the corporation, which is identified in the 1982 Federal Register because the interest was transferred to the corporation. So when the corporation charter was revoked, then the interests under the 1980 Act would, of course, revert to the lineal descendants. The Prairie Island Indian Community in the state of Minnesota is not mentioned in the statute, not mentioned in the Federal Register, not mentioned anywhere. And so the community's position would be, well, we revoked the corporation and then everything's fine. No, the interests were in the corporation. The corporation was revoked by statute, so it falls back. And there are several instances I want to mention as well, whether we identify in the complaint that once the Mdewakanton Sioux Indians of Minnesota are recognized, they become the nation then, which can then bring the sort of the treaty-based claims that have evaded the 1863 Act, which terminated treaties. For example, the half-breed tract near Wabasha could be an issue that would come up. There are also other sort of hunting and fishing right issues that could be resolved. And so we would have an entity, just like the Ojibwe and the Chippewa have, that they would sue for what rights they have. The three communities presently, Prairie Island, Shakopee, and Lower Sioux, are not legal successors to the Mdewakanton Sioux Indians of Minnesota, so they can't sue. So there's sort of a new sheriff in town, if you will, right? And that would be the new tribe would be able to pursue these claims that are long since should have been pursued. And I think everyone who's experienced in this would know that the Dakota have never been properly represented in any of the federal proceedings. So you think of something like the Indian Claims Commission proceeding in the 40s, 50s, 60s, 70s, 80s, and still the settlement checks haven't been completely distributed. But the three communities were there, but no one was properly representing the Minnesota Sioux Indians of Minnesota, the Mdewakanton Sioux Indians of Minnesota. So that's a big gap, and we'd like to review all those things. There needs to almost be, once the Mdewakanton Sioux Indians of Minnesota are acknowledged, the federal government should provide an accounting, right? I mean, so look, you've acknowledged us, but you haven't given us consultation, you haven't given us our rights, so why don't we have an accounting to the Mdewakanton Sioux Indians of Minnesota so that we can have that consultation and that sort of peace we desire. Are there any further questions? All right, thank you for coming, and thank you, everyone.
Thank you.
Thank you.
Good job.
Thanks.
Do you want to